All right. Well, thank you for joining us today. This is the first episode of our new podcast, the Co-Condo Corner. My name is Matthew Eiben. I'm an attorney here at Rosenberg and Estes. So the goal of the show is to kind of discuss with various guests in the industry certain issues with co-op and condo apartments and the operation of those buildings. And one of the issues that we were discussing today are UCC auctions, which I know you are personally familiar with. So why don't you give a little introduction of yourself, and then we'll go from there.
Sure. First, happy to be here. Thank you. This is my first podcast, so pretty excited for that, especially to be with your firm. We actually worked together for well before I even came to become an auctioneer. So happy to be here. Once again, my name is Matthew Mannion, and I own Mannion Auctions, which is an auction house that specializes in co-op foreclosures as well as other UCC foreclosures. And I also own JP&R Advertising Agency, which kind of go hand in hand. I get hired to do auctions, and then we do the marketing for the auctions. I've been at Mannion Auctions and JP&R since 2017. Prior to that, I've spent 5 years active duty in the Marine Corps as an infantry officer, which is very different than being an auctioneer. But you have to yell in the auctioneer and military, so maybe it kind of helped me out somehow. And services I offer are co-op foreclosures. So, your firm's very well versed in co-ops, but it's a very niche part of the law. So often I get contacted by attorneys who practice in other parts of the law and they want to do foreclosures, and I assist them with co-op foreclosures. I also do real property mortgage foreclosure services. I can't be a auctioneer for that. As I'm sure you know, you have to be a court-appointed referee, which means you have to be an attorney. I'm not an attorney, which I do have to say often sometimes. So there's no liability on my end if I'm giving advice. And so I cover the whole state of New York for mortgage foreclosures. And I help from the judgment getting signed by the judge up to the sale date. There are called a dozen steps that have to be done. Generally, you could have paralegals do that or attorneys do that. And then if you run a firm that goes through a lot of foreclosures, I call them like law factories, basically. They just do foreclosure work.
Yeah.
It's easier for them to outsource it to me. And that's my main revenue stream, is the advertising for mortgage foreclosures.
Gotcha. Okay. Yeah, I know. You and I met originally doing UCC auctions for co-op apartments. I was doing it on behalf of board of directors for failure to pay, maintenance and things like that. And you're absolutely right. I mean, it's a very niche industry, and there's really not a lot of information on it. And I found that out the hard way when I went to go do it, and there's no guides really. There's very rough guides. Bergman has an attorney who has a guidebook, but it's bare bones. And you can look at case law. But otherwise, you're kind of left to your own devices. And actually, you were very helpful in kind of laying the groundwork for, what some of those steps are, which we can talk about briefly, because, again, there's just not a lot of information on it. I guess the first step, or a little bit of background on what you're looking at. So for a co-op apartment, that's governed typically by a proprietary lease, which governs the occupancy for the shareholder. It's not real estate in the traditional sense. It is essentially a shareholder is an owner of shares of the corporation itself. So they are an owner of personal property. So that's what takes it out of the typical real estate foreclosure, where you'd have to start a court case, and you get into instead a non-judicial foreclosure, which is what we're dealing with co-op apartments. So the first step is typically the board will retain an attorney, serve a rent demand, start a non-payment proceeding in housing court, evict the shareholder, and at that point they would come to you and you kind of get involved. And first of all, I guess we would run a UCC lien search, and then maybe you can talk a little bit about some of the notices that would then go out after that.
Sure. Yeah. And it's going back to one thing you said, the eviction process. Every firm does a little different. I believe when we did the one that we worked on together, you evicted first and then we went forward with the auction.
That's a good point. Yeah. Because that's true. You don't have to. I mean, I've always found that, and I guess this hasn't been tested, but I mean, to have the person evicted, I think it kind of cleans the whole process up. I think if you leave them in possession and then you go forward with an auction, I think you're more likely to run into emergency orders to show cause. Basically, the shareholder running to court and saying, "Stop the auction. I have X, Y, and Z defenses. They screwed up here, here, and here." Whereas if you're out, you have basically a court order saying, you were the co-op apartment or co-op owner. You were right. You're entitled to the apartment, and you're allowed to go forward with this foreclosure auction. So that's why I've always found to do it. But there are certainly situations where maybe that's not feasible. Maybe you just need to kind of rush the process a little bit.
Yeah, I think you hit the nail on the head. If there's any co-op board members listening to this, that getting eviction first is the cleaner way to do it. Like you said. Yeah. You don't have to worry about an order to show cause getting filed the last minute. I've been a part of co-op auctions that take 4, 5, 6 iterations of publications, noticing, and all of that comes with a lot of attorney's fees and advertising fees and auctioneer fees, depending on when the cancellation occurs. If you do the eviction and then you do the process, now obviously you're going to have to pay for the eviction. There's positives and negatives. For example, let's say you have a shareholder that left the country. They're not talking. You have no idea where they are. You haven't been in contact with them for a year or more. Sure, they could still come back. But in that case, you might want to leave them in place and then have someone pay to evict them out of the unit. But again, you can do either. I would say 70% of the time they get evicted first. Because you said it's just cleaner. That it's not occupied. You're not going to have a last minute thing come up, and then you can do the auction. Okay, so getting to the notices. So there are 2 notices. Let's call it 3 notices that would be used, in my opinion, to get a good process going for UCC's sales of co-ops. One thing to keep in mind is, as you stated, there's no there's no law, there's no way to do this per the UCC. It doesn't give you the exact steps to do it. It just says If you give 10 days notice, that's reasonable. That's not reasonable in practice. And same thing with these notices I'm about to tell you about. You're not going to find these written out verbatim in anywhere. You're going to have to decide as the attorney, and that's where I come help to make sure you know the content of the notices. So after you do the lien search, you said, which, by the way, is one of the most important steps, because the only way this could really get screwed up, not the only way, but one of the largest, most often ways it gets screwed up is if the notification process is done wrong. So if you don't know who to notice and when to notice them, and they come back the day before the sale and say, "Hey, I have a lien on this and you never contacted me," you have to start completely over again. Yeah. So lien search, UCC judgment search, do all that first. And then the next one I would say would be a notice to cure, which is, call it a 60-day notice or 90-day notice. Again, none of those times are set anywhere in the UCC. You do a notice to cure. Notice to cure would be, you haven't paid 6 months of maintenance. We've incurred this much legal fees to this point. No later than, call it 30 days from that notification. To cure your default, you must pay XYZ, the amount of money that you owe by that point.
But that notice would actually be before the eviction, though, right? That's like you're referring to like a default notice under the proprietary lease, or is this in addition to that?
Right. I'm looking now. I'm doing the thing because there's 2 ways to do it. If you already sent that, if they've already been evicted, you don't have to do that.
Right.
We'll assume that we already evicted someone. In that case, the next notice I would suggest would be a notice of disposition of collateral. In the notice of disposition of collateral, you're going to inform the shareholder, even if they're not living there still, you need to still send it to the address that is being foreclosed on. Additionally, if you have any new addresses for the previous shareholder that you are aware of, you must send it to them. Any attorneys that you're aware of must be sent to them, and anyone that appeared on the judgment lien search that you had completed.
So, and that notice, I think technically really only applies to where it's a secure transaction, where it's the shareholder had gotten a loan and the mortgager is, the mortgage company is then trying to foreclose on that loan.
That's
technically. But do you still find that the like co-op apartment corporations are serving that notice as well? I think we ended up doing that in our case. I'm trying to remember, but
I think we did it to be belt and suspenders because,
right.
in my opinion, it takes. I mean, that one notice that we're discussing now, that's called the predisposition notice, and that is actually verbatim from the UCC. As you stated, that's for the language in it concerns if you have provided funding or financing to a co-op apartment, and you're doing
connection with the purchase of it. I think they even say, yeah,
right, yeah. So that notice, I don't think we needed to do that for the one we did, but again, I mean, it's already that language actually is verbatim from the UCC, so that takes 5 minutes to do. Right. I would say 9 times out of 10 for co-op boards as the foreclosing party do not send those. Now, the notice I'm referring to is the notice of disposition of collateral, not the predisposition notice. The predisposition notice is the one that we're talking, where it's like you get a notice in the mail and it says, here's the website, you can find information out about your rights. You might be in danger of losing your home. Notice disposition of collateral is not a predetermined set of words that you must send. And that's one where the notice of disposition is what gets mailed out. The notice of sale for publication is what gets published. And basically the only difference between those two is the audience, right? So the notice of disposition goes to anyone that either lives or has lived, or anyone that's involved in having a lien in the apartment would get that. And that basically tells them the date that we're going to have the sale, the amount of the arrears as of the date of the sending of the notice, some of the rules of the way we're going to get to the auction, and basically it's informing them that we're gonna sell your shares in your lease. Right,
and give very basic information, or at least instructions on how you can find information about the apartment itself.
Right, exactly.
So that's like what I think I've usually called it a notice of sale. So that's what you're referring to. Got it.
Yeah, exactly. And there's no even, that's not a technical term, notice of disposition.
Right.
And then the notice of sale is what you publish. And typically I suggest that both of those have to get mailed out to, we'll call them the primary parties at some point. I suggest you might as well just draft both in the beginning and then just send them together. And then you can refer to the one you're publishing in your notice of disposition as an addendum or an annex.
Okay.
Yeah.
Interesting.
So those are the notices that I think get involved on co-op deals in which the shareholder has already been evicted.
Got it. Okay. All right. So, another question, which may not seem so obvious, but who are the parties that are coming to these auctions that are and end up actually buying these apartments? Because I found that to be interesting, because it wasn't exactly what I expected going into the situation. And what I ended up finding, that it was a lot of the same people showing up to these. So anyway, I know you have a lot of experience with that.
Yeah. I have like a crew of individuals who follow me depending on what auction, which county I'm doing. Typically I hold all my auctions at the county courthouse of the respective county. And depending on the county, I have this different crew follows me. And you're right. It's a lot of the same people. I think the reason for that is a couple things. One, it's a weird process. There's, if you go to a judicial sale, you're dealing with a court-appointed referee. There's attorneys involved for the plaintiff. There's someone there bidding on behalf of the plaintiff. There's rules of the road that you can find and you know how it works. For co-ops, if you're not scouring the Daily News or the Brooklyn Daily Eagle for the notices, it's going to be hard to find out that there's going on anyway. So what you tend to get is professional investors. Now, if you go to a real property sale Wednesdays in Manhattan, there'll be a group of 50 people there try to buy properties. If you go to a co-op sale for possibly the same apartment, even the same building, you'll find 4 people there, and they're all professional investors. And the reason why you get less people too is because for co-op board, if you purchase the unit at auction, you still have to be approved by the board,
Right.
no matter what. Very often, most boards do not want investors. They want end users to purchase, and then they can approve those end users, and then they'll live there. By the nature of a co-op, they want to be exclusive. I think that's probably pretty fair to say.
Yeah.
And so they don't want investors there because, for a litany of reasons.
I mean, it's interesting. I mean, co-op, the idea is that you're basically buying into a community of people. And so they want to make sure that you're going to fit with that community. And then obviously they also have concerns about the financial capabilities. They don't want to have to chase people who are not, capable of fulfilling their obligations financially. But that's really just part of it. And like you said, most sales or almost all sales for co-ops, absent a few specific exceptions, are subject to board approval, which typically can be withheld for any reason or no reason at all. Most boards are not going to want some investor who's going to maybe lowball some renovations in the apartment, try and flip it, and not be the type of person who they want to be living in the apartment. Or if they can't sell it, end up being in default and being in the same situation all over again. Yeah,
the good point. The good point there is you can get denied for any reason or no reason. They do not have to tell you. However, that has changed actually in Westchester. They're, I think every year or two they try to challenge this, saying that it's, sexist, racist, the religion, whatever you want to call it. And in the 5 boroughs, they've maintained the ability to say to anybody, we don't want you to live here, and we don't have to tell you why, and we won't tell you why. That's true. That's anywhere. You can't do it for illegitimate reasons.
Typically, it's a difficult thing to kind of flesh out as to what the reasons are. I mean, typically there's plenty of reasons why they could, actually deny them. And this isn't a conversation that's going to be recorded. These are board members in a private room who look at this stuff, and it's memorialized with, a resolution saying denied, rejected, and they don't give a reason.
Yeah.
So,
they don't have to.
Right, exactly.
They do now. That just changed. I believe in this year, it changed now. Westchester County, you have to give a reason why, and that.
Interesting.
Attorney, that you'd have to think about that statement a lot about how you're going to deny somebody.
That's fascinating. Okay, I didn't even realize that. I mean, my practice is mainly in New York City, so we don't really do a lot of auctions out there. But that's very interesting.
It is. So I think it's going to open up a lot more investors that are going to want to go there because, if you could just get a toe in the door and say, oh, they denied me because X, Y, Z, then you can litigate, and then it's going to be a disaster for the co-op boards. But,
right. It takes some of that leverage away from the board.
Totally.
Mm-hmm. Okay. Interesting. But in addition to the professional investors, which I want to ask a couple more questions about that too. There are occasionally just legitimate people off the street, although I think they end up finding themselves in a situation where they're a little bit in over their heads as far as what they're dealing with. But I have seen them win the auction. I'm trying to remember. I think at least one of them, ended up moving into the apartment. And that was we had 10 people there. There was the whole normal crew of investors, and then this guy who was off the street and trying to find his apartment. So it does happen. The other people they could be people within the corporation or shareholders within the corporation. There's nothing against a board member or the corporation itself in trying to win the auction. I mean, typically, we can go into some of the dynamics or the kind of how the auction actually plays out. But the opening bid is typically the debt, the co-op's debt. In the case of where an apartment corporation is actually doing the auction. So if no one bids above that amount, they would win and they would be the owner of that apartment, and they can either sublet it or sell it. They could renovate it, do whatever they want, just like any other owner. But anyway, I just thought that was an interesting aspect. So, but back to the investors. So after these guys, let's say they win the auction because they have a little bit better finger on the pulse on what the actual value is and how much they can squeeze out of it. What are they doing after they win the auction, if you know?
Yeah, so typically, I've asked these investors the same question too, because I'm interested in what their strategies are. Generally, they will be, if they're experienced, I think that what they do is they be upfront. They're upfront with the co-op boards. They buy it, and they, in the terms of sale, it says no investors. They know that. The co-op board knows that. The investor that is savvy shows up and says, listen, I'm not going to live here. You don't want me to live here. I can't live here even if I wanted to, because you're not going to approve me. Let me come in. I'm going to renovate it. Let me show you what other stuff I've done that I've renovated other co-ops before, assuming it looks good. And then you would say, listen, I'm going to come in. I'm going to renovate it. It's going to look great. And then I'm going to find you a buyer. I'm going to find a buyer for the apartment that's going to get approved by you anyway. And the risk to the co-op is really nil if you think about it, because, again, anyone that lives there must be approved by the board. So if this gentleman or woman comes in and renovates this place and they can't find a buyer for a year, now if that person's not paying the maintenance during that time, that's not good. But if they're paying the maintenance while they're renovating it and while they're finding a buyer, then it's no harm, no foul. So I think that's what they would do, because they don't really have. The other thing you could do is just litigate. If you win the auction, and you can say, oh, they're not denying me because of whatever. But that's hard to fight when the terms of sale say we don't want investors, and then you're an investor. But yeah, I think
some of these guys, they'll make you start that lawsuit though, right? And then they'll hold the fire. Yeah.
There are gentlemen that I know that are investors that are very savvy when it comes to litigation, when it comes to these auctions, that know this portion of the law very, 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 very well, and knows the case law and knows the precedents that are set. And if given an inch, we'll take a mile, and we'll wrap up co-ops in litigation. And that, it's a strategy. If you do that and you do it enough and people know that you do that, maybe it's not worth their time to get wrapped up in a lawsuit for a year or two. Now, that might be good you might get some good lawyer fees from that, but the co-op board doesn't want that.
Yeah. When you sit down to have that conversation, like you were saying, where they make their pitch to the board, the unspoken statement behind that is, or the alternative is that we litigate and I drag this out for a few months and punish you.
I think it's definitely possible. I don't know if it's that prevalent. I feel like I don't know if you can litigate over, just winning an auction, and then, I guess you could probably find anything to make a stink about. But I think that if
I'm curious,
yeah, go ahead.
Do they close on the sale? These investors, if they win, are they closing on the sale and they're paying the maintenance during this process and then finding a new buyer? Is that basically how it plays out?
Yep. Okay. Exactly. Yeah, they still have to close because they still have to get the ownership of the unit to be able to, gut renovate or whatever they're going to do to it. So yes, they close. I think that they try to sweeten the deal, at least from some of the investors I speak to. They try to sweeten the deal and they say, listen, up front, I'm going to pay 6 months maintenance. If you let me close, I'll close immediately, to try to be above board of like, hey, listen, I'm serious about this. This is my job. But again, a lot of boards hear that and still say, nope, get out of here. And I get that, you might not want to deal with it. It's a headache.
Right.
It's an unknown. Whereas someone that comes off the street, like you said, it happens every now and then. I would say maybe less than 5% of the time that happens, that you get an end user. Now, that percentage changes when you talk about high value apartments in Manhattan or Brooklyn. Those generally generate a lot more leads, and you get a lot more action at auction, and you get a lot of end users. And what's interesting about that is those end users, the investors can't really compete with them because the investors still need to make a margin.
Right.
So if you're an end user and you get it 5% under market value, if you're talking about a couple $1 million house, that's great. But an investor's not going to do that. It's probably not worth the money for the time.
Interesting.
Yep.
So I don't know if we talked about it, but just to make clear again, so basically the governing principle behind co-op auctions is commercially reasonable. That's really all the statute says. So that involves the publication, sending these notices to the interested parties, the creditor, other creditors, the debtor himself or herself, and then you publish the notice of sale. And then what happens at the auction itself? And where are those typically taking place in your experience?
So, yeah, right. So publication, generally, I suggest you publish once a week for 3 weeks. I have some clients that want to do 4 weeks. Reason being is, and this is something I think that we might have talked about during our deal, is I try to mimic the real property law, not to a T directly, but generally follow it. Reason being is that's laid out line by line of how to do it correctly, including publication requirements. So I think if we stay close to that, you don't have to do it exactly because it's not real property, but if you stay close to that, if you and I found ourselves in front of a judge and he said, well, why did you do X, Y, Z? And we can say, well, in RPAPL 231, it says do this, and we did 95% of that. That makes us look way more defensible than not.
Especially because, again, there's just not anything in the statute. You could look to case law, but, that's going to depend on your jurisdiction and whether or not it's actually precedent. So it makes sense to look to the most similar situation, which, would be a condo apartment, for instance, which is, from a layman's perspective, it's the same thing as a co-op apartment. Legally, they're very different, but I mean, I can see how a court would say, all right, well, if it's fine here, why aren't you doing that with a co-op apartment right across the street? So, I think that's smart. That seems pretty prudent.
Yep. And then for the locations, besides, Manhattan now is still outside, but I think that's moving back inside. Most of the counties is done at the steps of the courthouse, front steps of the courthouse, like it has been for, I think there's records of people doing that in like the 1800s in New York. They're like the town crier, they're outside and they give the announcement, and then people show up at the auction and bid. Yeah, Manhattan, I think it was in the Rotunda. I think we're going back to that. Thankfully. I did a partition auction a couple weeks ago from a family that they own 6 buildings in the West Village, and it was like $60 million total. Family couldn't get along. Court said, "All right, you're going to split up all the properties. You split the proceeds," and it was like 20 degrees outside, and we had like 100 people bidding, and attorneys that are in their 80s. It's and other people in their 80s too, and we're outside freezing our butts off. So it really goes in. But yeah, most of them are outside the courthouse. Sometimes it's the office.
I used to do them at my firm's office or my prior firm's office, and you bring up the cold temperature, and I remember. It's kind of related. So it was a small building, and the elevator, it was a single elevator, and it stopped working 2 hours before the auction. And I was freaking out. I drafted this whole notice about like where it's going to take place. And thankfully at the last second it turned back on, but it was a panic because if I was going to make these people or these potential, participants walk up 5 flights of stairs, is that commercially reasonable?
Probably not.
I would say probably not. But is it commercially reasonable to make somebody stand in 20-degree weather? It's probably in those circumstances, but it's an interesting thing that you have to think about in those final moments leading up to the auction. Even
definitely.
Mm-hmm. So you talked a little bit about some of the other auctions that you've done. Is there any particular type that you're seeing ramp up more recently, or a new type of auction that people are utilizing? I know we talked about this a little bit in our call a couple weeks ago.
So maybe it's just I'm getting more of them than I did before COVID, but I'm seeing a large uptick in large membership interest auctions. Membership interest auctions are UCC auctions. They fall under the same exact part of the UCC as a co-op does, with a little differences. Like the predisposition notice applies only to co-op shares. Obviously doesn't apply here. But essentially what it is a LLC. John Doe LLC owns 100% membership interest in Jane Doe LLC, and then Jane Doe LLC owns a building in Manhattan or a building in Los Angeles, and then Jane Doe stops paying John Doe, who's the lender, and then you hold a UCC sale, the membership interests. And it's very weird the way what they do is when they originate the loan, they have a mortgage, and then they also have a security agreement, pledge agreement at the same time. So that way they have two ways to cure. If you stop paying the mortgage, they can say, all right, well, we're going to go through a judicial route, which, as you know, right now, if it's in Manhattan, you're looking at July at earliest.
Yeah.
And that's for people that maybe don't have deep pockets. If you have deep pockets and you can pay for really good attorneys, you could drag that out for 3 years in the judicial process. UCC, now that's going to take a lot of lawyer fees, but UCC auction, you could do 90 to 100 days and to have a rock solid process. Now, if you're talking about like $100 million tower in LA, which is what I'm doing right now, you're talking $50,000, $75,000 of advertising on the beginning. Not to mention you're going to have to hire a broker. That's going to be another $100K plus. Not to mention you have to hire a great law firm. That's not going to be cheap. So those prices make people, kind of go judicial route more often. But I think because of COVID, you could do UCC auctions during COVID. You could not do judicial auctions. I think more people are doing these UCC auctions, going through the security agreement, pledge agreement route rather than the judicial route.
Right. Yeah. I mean, the other thing is that, ultimately, I think it's a quick way of putting this, the squeeze, so to speak, on the debtor, where they can't just, count on delaying and motion practice in court. They're going to have to file an order to show cause and be in front of court immediately. At which point, that's an opportunity to have another sit down discussion and try and meet a resolution, or bring in other parties, et cetera, and be creative. So that's interesting, though. That makes sense. I know our firm does some of those. I think you said you would work with another attorney at our firm before.
Yeah, Stacy Lahr, I think that was the right name. Stacy and I did a couple of UCC auctions together. And you made a great point there, putting their feet to the fire. A lot of this is just getting the borrower to come to the table.
Right.
And when you start sending the disposition notices out and you say, if you don't, we're going to set the auction sale. We have auctioneer hired already. We're publishing in the Wall Street Journal, New York Times. You got a month until we do the sale. A lot of the times these auctions get canceled at the last minute. The borrower says, all right, fine. We can tell you're serious. What's the number you want? And sometimes they get the right number. Sometimes they don't. We hold the auction anyway. Mm-hmm. Sometimes it comes down to a minute before the auction and the wire comes through and then auction canceled. I still get paid during that, but it's a good way to keep their feet to the fire. And a lot of these get canceled. I would say for the big auctions, like anything over 10 million, from the process beginning to actually getting to an auction probably happens only 65% of the time.
Interesting.
Yeah.
Okay. I think we pretty much covered everything that we wanted to, unless there's any other topic or issue that you wanted to discuss.
No. I should have had some more questions for you. That's kind of a one-sided affair today. No, I think we hit everything pretty much on the head here. I think Mannion Auctions LLC, Rosenberg and Estes. If you're co-op board and you need some co-ops sold, we could help you out.
Yeah, no, listen. I mean, I think the thesis is that it's a complicated process, and you need to bring in people who know what they're doing, because you can get yourself into trouble and drag out these issues even further. And for co-op apartments, cooperatives, that can be a big issue. If they are owed a lot of money, that could drag out years and years, and I've seen that. So it's important to bring in the right people at the right time and really push this and expedite it to get the money that you need to operate the building. So
totally agree.
All right, great. So I think that's it. I think that's good for our first episode. If anybody who's listening or watching, if there's any other questions, if there's any topics you want us to discuss, feel free to reach out. I can post my email, but it's meiben@rosenbergestes.com. And I think that's it for today. So thank you for joining us.
My pleasure. Thanks for having me.
All right. Thanks, Matt.